This is case number 21-344425. This is Candace Corley versus Jesse Godwin and other occupants of property located at 12570 Lang Street. The court is also calling the suffix 8508. That is Kingman Holdings LLC versus Carlisa Wright. The court calls the suffix 3469. That is Lafayette Towers Apartments versus Feliciano Moreno and other occupants of property located at 1301 Orleans, number 1212. The court calls the suffix 1514. That's Linwood Apartments LLC versus Jalen Gershon and other occupants of property at 15395 Linwood, apartment number 202. The court addresses 4425. Your appearance at this time, counsel. Regarding Mr. Pantera, are you there, sir? All right, it appears in this matter that there has been a request for adjournment in light of service issues. The court will grant that adjournment, setting the matter over for 6/14 at 9:30 a.m. and so ordered at this time. The court addresses now 8508. That is Kingman versus Carlisa Wright for the plaintiff in this matter, please. Mr. Fleshman, are you on this matter?
Yes, he should be.
Your appearance, Mr. Fleshman, regarding the Kingman Holdings LLC.
Yes, Your Honor. May it please the court, Dennis Flesland, P30289, appearing on behalf of the plaintiff. I'm standing in for Mr. Sagatti this morning, Your Honor.
Thank you, counsel. For defendant in this matter.
Charlene Snow from United Community Housing Coalition, P26923. On behalf of Ms. Wright, I don't know if she is in the courtroom on a telephone or not.
All right, Ms. Carlisa Wright, are you there, ma'am? All right, you may proceed, Madam Counsel, to update me on this matter, please.
Your Honor, I understand by a telephone call on the 5th of April that Ms. Wright moved out of the property. She had not at that time returned the keys. She had reached out to representatives of the plaintiff and could not get a response from them as to how and where to return the keys. I have emailed and telephoned her since we were here on 4/7 and have not heard back from her in writing as to the fact that she's moved. But my understanding is she has moved. So that's where we are. And I asked Mr. Fleshland this morning whether his client has been out to the property to see if the place appears to be vacated.
He can't, he doesn't know, Your Honor. He'll check on it, but he didn't know that she had moved out or said that she had moved out. So, Your Honor,
we had discussed it on the 7th that she had moved.
Yeah, Ms. Snow can correct me if I'm wrong, but I believe she and Mr. Sagatti had discussed converting this matter to a termination case and fixing a move out date. And I don't know if Ms. Snow is willing to do that still now, just to enter a judgment to get this case completed, or.
Well,
Your Honor, we were talking about a move out date of April 11 on the document that Mr. Sagatti sent me. And on April 5, the lady said to me on the telephone that she had already moved out. So I'm not sure if they've got possession or should have possession that there's any case here.
Well, you know how it goes. I mean, somebody leaves some stuff in there and they don't get it all moved out, and the landlord likes to have a judgment just to make sure that they can get it moved out without having any liability. That's the only thing I'm thinking about.
I'll
give her 10 days. I can go along with that if she's already out.
I'll grant an order. I'll grant an order conditionally dismissing the matter and allowing in that order that the plaintiff has access to the premises and may remove any items on the premises. If the plaintiff somehow discovers that the tenant is still occupying the property, then the case would be reinstated and the court would enter a judgment at that time. At this time, I'll grant an order dismissing the case conditioned upon the premises being made available to the to the plaintiff based upon representations from the defendant as she has moved out of the property. So ordered, and I'll sign an order upon this presented.
Okay, Your Honor, thank you.
All right, thank you.
Very well. Thank you, Judge.
Thank you.
I'll send you something, Charlene.
All right, the court is referencing now 3469 Lafayette Towers versus Randall. Your appearance, Mr. Coleman, are you there, sir? For the defendant in this matter.
Judge Steve Lockhart, P32090, standing in for defense attorney of record Susan Rock. Judge, I just returned from another courtroom. Did Mr. Randall check in this morning, if the court officer knows?
Let's check and see. Mr. Randall, are you there? My court officer indicates that there's been no check-in by Mr. Randall. This is a subsequent hearing in this matter. Counsel?
Judge, I think we might need to defer to Ms. Rock. I can tell the court that apparently there was an agreement between Rock and plaintiff's attorney Coleman with possibly a vacate date certain conditional dismissal, but Ms. Rock has lost communication with defendant and doesn't have authority to enter same. It's possible we need Mr. Coleman and Ms. Rock, but that is what I can tell the court as to my understanding of the current status. This is a second hearing on a health hazard.
Yes, sir. Yes, sir. I'm going to stand down on that one for right now. I'll recall it as Mr. Coleman comes in, sir. Thank you.
Thanks,
the court now addresses the suffix 1514 Linwood versus Gershon. It looks like that's Mr. Coleman's as well. Mr. Salami, your appearance at this time for defendant, sir.
Hassan Salmi from the United Community Housing Coalition, P82497, on behalf of defendant.
Sir, any update that might, any update that you can bring to my attention at this time?
Yes, Your Honor. I think this was going to just be an adjournment as my client has processed the SARA application. I was just going to get some things on the record. I don't know if it would be more appropriate to do it now or when Mr. Coleman comes, but just some, yeah.
I may need to step back and deal with it when Mr. Coleman comes up. But
yeah, but that's where it's going most likely, but that's where it is right now. Thank you, Your Honor.
Yes, sir. Thank you, sir. All right, this is case number 21-342-786. This is 21st Mortgage Corporation versus Cecilia Embry and other occupants of property located at 20012 St. Alban. The court calls the suffix 2081. That's Philip Carter versus Alexis Monet Myrick and other occupants of property located at 18541 Westmoreland. The court calls the suffix 2645. That's Wonderful Structure LLC versus Chris Chandler and other occupants of property at 14232 Frankfurt. The court calls the suffix 4194. That involves Mutual Property versus Barry Frederick and other occupants of property located in the city of Detroit at 3930 14th Street, apartment number 103. The court is calling 1249 suffix Friendship Metals LLC versus Charles Pruitt and other occupants of property located at 1001 Leland, apartment number 113. The court is calling the suffix 4206. That is St. James Cooperative versus Anthony Bradford and other occupants of property located at 17254 Bentler Street. The court calls the suffix 7798. That's Rasol USA LLC versus Darcadia Leon and other occupants of property located in the city of Detroit. That location is 18911 Mansfield. The court calls the suffix 1537. That's 360 Management LLC versus Jamaria Blackshear and other occupants at 9317 Bedford. The court calls 8805. That's a prefix of 20. That's L&J Investments versus Yvonne and Alvin Grimes and other occupants of property located at 19220 Gainesboro. The court now addresses the suffix 2786. Your appearance at this time, counsel.
Yes, good morning, Your Honor. David Drasnan, P45330, on behalf of 21st Mortgage Corporation.
Thank you, counsel. And do I have on the Zoom Miss Cecilia Embry, please? Right. Anyone for Miss Embry regarding the address on St. Albans Street? All right. This is a subsequent hearing regarding a complaint for recovery of possession of property. It appears now that the defendant has not appeared regarding this matter, nor has the defendant responded to the court's call. The court accordingly will enter the judgment now by default and will make the finding that the plaintiff has the right to possession, that the tenant must move from the property on or before the 23rd of April or after that date, a writ will issue allowing for eviction from the property. The court will sign the judgment upon presentment. Thank you, counsel.
Thank you, Your Honor. Is there a email address that I can forward that proposed judgment to?
Yes, sir. That's Latifah, Latifah, Latifah.hunter at 36districtcourt.org. That's 36th.
30, I'm sorry, 36, right, 36 DH
Yes.
District Court.org.
Yes, sir.
So once again, that's LATIFAH.hunter, HUNTER at 36 TH districtcourt.org.
That's correct. And I'm just saying the TH to make sure that's not just 36, it's 36. All right. Yes, sir.
Very good, Your Honor. I will submit that order to the court.
All right. Thank you, sir. All right. The court now addresses the suffix 2081. That is Philip Carter versus Myrick. Your appearance on that matter.
Kathleen Parak, Parakh, P7840 before, on behalf of Philip Carter.
All right, thank you, counsel. And Ms. Monet, Ms. Myrick, are you here on this matter?
Yep, I'm here.
All right. And so you, in this matter, it looks like there is an agreement for this case to be dismissed on conditions as set forth in the document presented to the court that the tenant would move from the property on before April the 12th of 2021. Is that the agreement in this matter, Ms. Croft?
Yes, it was, Your Honor.
All right. Yeah, Ms. Myrick, that's your agreement as well?
Well, remember last time when we did come to court, yes, that was the previous agreement.
Yeah,
But
Mr. Myrick, yeah, I'm sorry. I remember you now. I'm saying this is Mr. Myrick, so my apology. All right. So the last time that you were here, you indicated that you had suffered a physical ailment and was unable to move secondary to this COVID environment. And you also asked if there was consideration, if the other side would consider the possibility of CR-type funds. Is that the discussion that you brought before the court, sir?
Your Honor, we never talked about CR-type funds. That was never discussed. I don't believe.
Ms. Brock, you were not here. You were not here when the defendant came in at some other point.
He might have come in on, Your Honor. It was Monday that he came in. We never discussed, but I want to be on the record. We have never discussed Sarah funds. I did not know that there was a physical problem. Also, the last time we were here.
Let me stop you, Ms. Brock, because you did cut me off, and you know that anyway.
I know. I'm sorry. I apologize, Your Honor. You are correct.
I know that. I know that you weren't here, and I know that Mr. Mivers brought some things to the attention of the court, and I sent it over so that I could get you here, and so I was not putting that information out there as if that was something that you had known. I put it out there specifically because I know that was not something that had been brought up, because however this hearing came about previously, the last hearing, the last time that Mr. Myrick was here, you were not here. And so I just sent it over to see what can happen from here. So have you all discussed it at all, or what is your client's position regarding this matter this time?
My client does not want Sarah funds. He needs the property back. He needs to sell the property. They were asked to leave back in December, at the beginning of December, actually. And, you know, it's been over 4 months, actually 5 months since they've been asked to leave. He's not collected any rent. He's not interested in the rent. He just wants the property back.
All right, and Mr. Myers, is there anyone here that spoke with Mr. Myers that might be able to have some indication?
Judge, this is Lockhart.
Go ahead, Mr. Lockhart.
Judge, I was working your docket on Monday. This case was docketed to be heard on Monday. My understanding is at a previous hearing, the parties agreed, defendant in pro per, but having talked to a legal aid lawyer, agreed to vacate on April 12th of this year. The case was docketed on the 12th. On the 12th, Mr. Myrick represented to me and later on the record to you that subsequent to his agreement, he came down with the COVID illness. It left him unable
I get you to pop on and just deal with those. They should just be their first hearing, I think, just
told
adjournments.
Mr. Myrick about the Sarah program and asked if he had explored that with his plaintiff, and he indicated no. I believe Ms. Paruk has now addressed that, but the status as I know it is the defendant is claiming he's unable to fulfill the agreement due to the unforeseen illness that he succumbed to.
I thank you.
And I know the plaintiff's attorney has not been privy to any of that information until today, I suspect.
So, Mr. Myrick, they're not interested in the alternative of accepting any money. They just want you to move from the property. And obviously, the physical ailment was an intervening event here. How soon can you be out of there, sir?
Well, I can, if you can give me until the end of the month, like you were opting for on Monday, I can definitely have it. I mean, I can definitely vacate the property by then. And that's by guaranteed. I'm not gonna, I've been definitely taking the proper precautions so that way I don't get sick again and I won't have to lose so much time. So I do apologize for the inconvenience, of course, to the plaintiff and to the courts for, you know, taking up so much of this valuable time here, but I definitely intend on being out of the property. That's no problem. All
right, sir. Given the ailment, although not verified by documents, the circumstances here, I will allow the conditional dismissal to be sustained through April 30th. You have to be out of there April 30th. That basically gives you the weekend to be out of the property. If the defendant is not gone by April 30th, then the plaintiff may submit an order of judgment together with a writ for immediate execution. The court will sign the same.
Your Honor,
So
should
I'm
I?
sorry, ma'am.
Should I resubmit the conditional dismissal, but with the date changed?
If you would, with the language, the additional language that the court indicated. All right. All right. So I wish you well, Mr. Myrick. Good day to you,
Thank
sir.
you. You have a great day.
A great day.
Thank you, Your Honor. I apologize for interrupting. I didn't understand what you were saying.
No problem, ma'am. Good day. Good day to you. All right. The court addresses the suffix 2645. That's Wonderful Structure versus Chris Chandler. Your appearance at this time, please. I do see where I've received a substitution of counsel.
Good morning, Your Honor. Alan Dyer is appearing on behalf of the plaintiff.
All right, thank you, Mr. Dyer. Do I have Chris Chandler on the Zoom? Chris Chandler, any person occupying the property on Frankfurt, 14232 Frankfurt. Anyone with any information regarding Chris Chandler? This being a subsequent hearing, it appearing that the defendant has not appeared, the court will enter the judgment now by default finding that the plaintiff has the right to possession, that defendant must move the property on or before the 23rd of April 2021, or after that date, a writ will issue allowing for eviction from the property is so ordered. The court is addressing. Thank you, sir. The court is addressing the suffix 4194 mutual versus Barry Frederick. Counsel for the plaintiff, Mr. Lajami. Are you there, sir? Do I have Barry Frederick on the Zoom? Mr. Frederick, if you're on the Zoom, please say something at this time, Barry Frederick. This is the first hearing regarding a complaint for non-payment of rent. As the first hearing, the court will set the matter over for a subsequent hearing on the administrative order of the Supreme Court. That subsequent hearing will be May 18 at 9:00 a.m. May 18 at 9:00 a.m. If the defendant does not appear at that time, the court will entertain a motion for entry of default judgment. The court now addresses the suffix 1249, that's Friendship Metals versus Charles Pruitt, regarding the property located on Leland Street, number 113. Counsel, your appearance at this time, sir.
Good morning, Your Honor. Aaron Cox, P69346, appearing on behalf of the plaintiff.
Thank you, counsel. And for the defendant at this time.
Good morning, Your Honor. Angela Malvig, P83921 with Lakeshore Legal Aid on behalf of defendant Mr. Pruitt.
All right, thank you, Ms. Malvig. And this is a subsequent hearing on a complaint to recover possession of property. And you may proceed to update the Madam Counsel, please.
Yes, Your Honor. First, my client is having difficulty getting into the hearing. He has dialed the number and put in the meeting ID. I've had my office administrator walk him through it, and he's, for some reason, not able to connect. So he's trying again to get on the hearing here, but we have not been able to work out an agreement. I don't know if Mr. Cox would be amenable to discussing the case in a breakout room right now, or if we want to proceed to a hearing.
I think a discussion makes sense, Your Honor, if you can put us in a breakout room.
All right, I'll set that up right away. Let's see if we can get some traction going on this. So I'm going to be sending you to breakout room number 3. And Ms. Mulvig, you'll be getting a notification, Mr. Cox, as well.
Thank you, Judge.
The court now addresses 4206. That is St. James Cooperative versus Anthony Branford. Counsel for the plaintiff on this matter.
Your Honor, Julie Crota, P39367 on behalf of St. James Co-op.
All right, and good morning to you, Ms. Crota.
Good morning.
Do I have Anthony Bradford on this Zoom? Mr. Bradford, if you're there, say something, sir. Mr. Bradford, any person living at the property on Bentler Street, number 068. If you're on this matter, please say something at this time. All right. The defendant has not appeared regarding this matter. The court will set it for a second hearing based upon the administrative order. That hearing date is going to be 5/18/21 at 9:00 a.m. 5/18/21 at 9:00 a.m. is the next hearing date. Thank you, Madam Counsel.
Thank you, Your Honor.
The court is addressing the suffix 7798. That's Rasul versus De Leon. The matter is before the court for a subsequent hearing on a complaint for recovery of possession of property for the plaintiff at this time. Mr. Fleshland, you there, sir?
Yes, Your Honor. May it please the court, Dennis Fleshland, P30289, appearing on behalf of the plaintiff. I'm standing in for Mr. Sagati this morning, Your Honor.
All right, thank you, counsel.
I believe the defendant is here.
I'm sorry. All right, where's De Leon? Excuse me, Leon, last name? Where are you? Say good.
Good morning, I'm here.
All right, I do see you there. And so what's going on in this case, Mr. Fleshland? I know that Mr. Lockhart withdrew as counsel regarding this matter and signed an order.
Yes, Your Honor. The notes in the file here indicate that looks like yesterday or the day before yesterday, I guess, Mr. Sagati talked with the tenant and they had agreed to enter into a consent judgment, giving her 30 days to move out. I don't know if that's still agreeable to her or not.
Yes.
Ms. Leon, is that your agreement, ma'am?
Yes.
All right. All right, and you've had an opportunity to talk with a lawyer, and you understand what your rights are in relationship to this matter. And the agreement to enter into a consent that would allow you 30 days to move from the property. It would give you, that would be the 16th of April. You would have that weekend to, excuse me, I did that wrong. That would give you the 14th of May, and you would have that weekend to vacate the property. Is that in fact what you're willing to and would like to enter into at this time, ma'am?
Yes.
All right.
Yeah, that's agreeable.
All right, very well. I will sign an order consistent with that agreement, ma'am, and I will give you the extended time that you need to move from the property. I do wish you well, ma'am. Good day to you.
Your Honor, do I have permission to sign her name to a consent judgment, or how do you want me to handle the mechanics of that?
You just, Mr. Leon, I'm going to have him put your name on the document and say by consent on the record.
That's perfect for me. Thank you.
All right, thank you, ma'am. Good day to you.
Very good, Judge. I'll send that right down.
Thank you, sir. The court now addresses the suffix 1537. That's 360 Management versus Demaria Blackshear. Counsel in this matter, Mr. Callahan, are you there?
I am, Judge. Kevin Callahan, P78273, representing plaintiff in this matter.
Thank you, counsel. And do I have on this record Blackshear? Last name Blackshear, if you're on this record? Say something again.
Yes.
All right,
I'm here.
Good morning to you. You live at the property of Bedford, is that correct, ma'am?
Yes.
All right. And you spoke with an attorney regarding this matter the last time that you were here, is that true?
Yes.
Judge,
All right.
may I interject?
And you may at this time on this non-payment matter, Mr. Lockhart.
Judge Steve Lockhart, P32090. I am agreeing to represent Ms. Blackshear at her request. I will enter my appearance in this case. We'd be asking for a SARA adjournment, but I need to inform Mr. Callahan that there is the allegation that defendant went through the winter without heat. So there may be the 50-50 issue that is presented by SARA.
Whatever.
All right. Well,
this is the first time I'm hearing about this after months of that's ridiculous. Okay, thank you, Steve. Thank you, Judge.
Telling you what I've been told, Mr. Callahan, just so you know what's coming.
The what I'm going to sharpen Mr. Callahan on the whatever part. That doesn't fit real well within the context of any legal articulation. But I do get that you indicate that you've not been put on notice of these issues. So there is some notice that has been given in this regard. I will set it in the CR protocol to the extent that there is ongoing debate on the underlying issues. The court could conduct a hearing to determine underlying issues that might affect the dispersal of CR fund. So at this time, I'm setting the new date for 5/18/21 at 9:00 a.m.
Thank you. Kevin, I'll get back with you once I delineate.
Thanks, Steve. Appreciate it.
Take care.
Judge, I am attorney Brian Bouchart this morning as well. I don't know if you wanted to clear your docket of those as well.
I know you'd like for me to. I'll come right back to you. Just stay there. I'll come right back to you. I do have that in front.
Thanks, Judge.
All right. I am addressing now 8805. That's L&J Investment versus Yvonne and Alvin Grimes. I'm sorry. The matter is before the court regarding a complaint for land contract forfeiture. Your appearance, counsel.
Good morning, Your Honor.
Thank you. Just a lot of background noise.
Yeah, I'm working on that now. All right. All right. Go ahead, sir. Your appearance.
Good morning, Your Honor. Connor Clordy, P84485, standing in for Mr. Steve on behalf of L&J Investments.
All right. Thank you, counsel. And for the defendant in this matter.
Marilyn Mullane, P30998, Michigan Legal Services, appearing on behalf of the defendant, Yvonne Grimes, who is also in the courtroom.
All right. And good morning to you, Ms. Yvonne. Is it Grimes?
Yes, it is. Good morning.
All right. Good morning to you. Madam Counsel, Ms. Mullane, if you will update me on the status of things here, ma'am.
Yes, Your Honor. When we were last in court, the court had indicated that it recalled the case very clearly because Ms. Grimes had appeared in court from Beaumont Hospital from her hospital bed with the hospital nurse who put the call through. That was in February, and the court set the matter for March. The plaintiff came in waiving a default judgment that they indicate they had obtained in February. The court had a specific memory of the case and said that it had, when they called in within an hour, actually within 45 minutes of when they had been trying to get in when the case was scheduled, the court set it aside because of the situation, and we were to proceed on the merits. Now it's my understanding that the plaintiff has filed a motion for reconsideration of the court's decision setting aside the default, presumably on the grounds that the court had no authority to do that sua sponte. I'm not sure. I got a copy of it. Our response is due in a week. However, I responded last night. So the court should have a copy of the response in detail to their motion for reconsideration.
I have neither the motion nor the response. That does not mean that it has not come through somewhere, but we're dealing with multiple pieces of information, and that information has not made it to this court file. So I will need to set that for hearing, and we can do that right now. And I'll track the stuff. If I can put this over for 1 week, then I'll slip it in and I'll hear the arguments, and we'll make a decision as to the outcome of this matter.
All right.
So next Wednesday, the 21st, and I'll set the matter at 10 o'clock a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you to both of you. Sorry, I don't have the paperwork now, but we'll have it. I'll make sure it gets in the file at that time.
All right. Thank you. Ms. Grimes, you may leave.
Okay, thank you.
Good day to you, Ms. Grimes. See you next Wednesday.
You too, thank you.
The court is calling case number 2134, Mr. Cox and Ms. Movic. 1249 is the suffix on this matter. I'm sorry, is that Ms. on Friendship Metals versus Charles Pruitt?
Your Honor, this is Attorney Coleman. Mr. Cox had to go to another courtroom. He just texted me.
All right, very well. I'm sorry.
Mr. Pruitt has been calling on the phone. He can't get in. That's I guess your
Okay.
defendant.
So let him know that his attorney is here and that when we will come back to this matter shortly. Okay. All right. The court is, and Mr. Coleman, you're next up after this, 2-1-3-4-4-1-7-9. That is Martin Luther King 2 versus Lenora Boykins and other occupants of property at 1895 East Lerner. The court also calls the suffix 1780 regarding Emerald Springs versus Thomasina Laidler McConnell. Matters before the court for a subsequent hearing. Counsel, your appearance at this time. Mr. Callahan?
Yes, Judge. Kevin Callahan, plaintiff.
All right, thank you. Counsel, do I have on this Zoom, do I have Ms. Lenora Boykins, Ms. Boykins? Lenora Boykins? Yeah, I see you there. Unmute yourself, Ms. Boykins. *6. Ms. Boykins, I'm not hearing you. You got it. You on mute.
Judge, this is Lockhart. I did.
Can you hear me?
One second, Mr. Lockhart. Yes, Ms. Boykins. Good morning to you. Mr. Lockhart is having something to say. Just a moment, ma'am. Go ahead, Mr. Lockhart.
Judge, I just wanted to advise you, I talked to Ms. Boykins this morning if she was unable to connect, but you got her now. Pardon me.
Excellent. And is this an application for CR type situation?
Judge, this is a first hearing on a non-payment. Ms. Boykins indicates that she has been in communication with Mr. Bouchart's client to apparently there's payments she's made that have not been credited. This is a first hearing. I understand Mr. Callahan's just stepping into this. It's probably wisest to adjourn it so they can, plaintiff and defendant, can get together to show each other their receipts.
All All right, very well. I'm going to go ahead and set it over for 5/20/21 at 9:00 a.m. That'll be the next action date on this matter. Obviously, Ms. Boykins, it seems that you've been talking with the management and trying to work out a way to resolve the payments. Is that correct, ma'am?
Yes, it is, Your Honor.
All right. All right, so we'll revisit that on the next date. Obviously, if you get it worked out between now and then and get it all settled up, then that date might not be necessary. Somebody will submit an order of dismissal. So I do wish you well, ma'am. See you on the next date.
Thank you, Your Honor.
Thank you. All right, regarding the suffix 1780, do I have Ms. Laidler McConnell? Ms. McConnell, if you're on the Zoom, please say something at this time, ma'am. Occupant of property at 12056 Caldwell Street. Any person occupying that property on this Zoom, please say something at this time. This is a subsequent hearing where it appears that defendant has not appeared, nor has defendant responded to the court's call. Accordingly, the court now will enter judgment by default on the terms as prayed in the complaint, finding that the plaintiff has the right to possession. Defendant must pay the amount set forth in the complaint, subject to updates based on the expiration of time. And those amounts would have to be paid by the 23rd of April, 2021, or after that date, a written would issue allowing for eviction from the property sold.
Thank you.
I see Mr. Cox, you're back, sir. Ms. Mobic, are you there? Mr. Cox? And we're already on the record in 1514. That's been previously called also strike at 3469. The court also is calling at this time the case number 21-343454. That's Westport Property Management versus Francis Maddox and other occupants of property on McKinney Street, 10739 McKinney. The court calls the subjects 3458. That is the Dicheng, DICHENG Property Management versus Martise Dumont and other occupants of property at 16212 Washburn. The court is calling the suffix 3462. That is Own Homes LLC versus Caprice Howard and other occupants of property at 15905 Lappin Street. The court is calling the suffix 1563 Stacy Sims, that's right, that Open Doors versus Stacy Sims and other occupants of property at 7773 Penrod. Your appearance regarding these matters, counsel.
Your Honor, for the record, Attorney Frederick Coleman, P. 56548, on behalf of the plaintiffs in each of these matters. Your Honor, as to the matter ending in, I believe, 466, that matter is being dismissed if it has not been sent already. As to the matter ending in 454, pardon, Your Honor?
I just want to make sure I saw it. Okay, 466, that matter. Ms. Rock, where are you? She was here previously. All right, it is being dismissed. I will note that at this, Ms. Rock.
Judge Lockhart, Ms. Rock is on 469, not 466.
So wait a minute. Which one did you say is dismissed, Mr.?
This is over here.
Oh, I didn't call that one, Mr. Coleman. All right, that's
okay.
That's because that's already dismissed. All right, got you, Mr. Coleman. Mr. Coleman, you can continue now.
All right, Your Honor, as to the case ending in 454, 458, and hold on, what's this one? And 462. These matters before the court previously on March 31st. At that time, our service was defective. We have since obtained service. So based upon that, this would be a first hearing on these three matters. And we're asking to be adjourned so that, and we're going to provide this, the proof of service, because I looked at the register of action this morning. They're not within the files. We're going to send those proof of services over to Madam Clerk this morning.
Thank you, Counsel. Let me check and see now. Do I have Francis Maddox here? Is Francis Maddox here in the court?
Yes.
All right. Good morning to you, Ms. Maddox. Have you, well, let me tell you, this is a first hearing regarding a complaint for non-payment of rent regarding the property there on McKinney. Have you had an opportunity to speak with a lawyer regarding this matter, ma'am?
No, the Westport properties, they don't even own this house any longer. They haven't owned the house for over a month now.
All right. So ma'am, who are you renting it from?
Now I pay it to West Cam. It's owned by West Cam Investment.
All right. And are you behind in any amount of rent, ma'am?
No.
All right. So I'm going to let you talk with a lawyer regarding this matter because there is a claim by Westport that there is some $5,200 in past due rent. So I'm going to let you talk with a lawyer. I'm going to set a subsequent date regarding this matter. That date's going to be 5/20/21 at 9 o'clock a.m. You got to come back into the Zoom on that date.
5/20?
Yeah, 5/20 at 9 o'clock a.m., ma'am.
Okay, so now do I talk to attorney now or what?
Yeah, I'm going to send you to a breakout room to talk with someone, ma'am. Just one moment. So who's available at this time to talk with Ms. Maddox, please? Mr. Salome?
I'm sorry, I didn't hear you.
Just be quiet for a moment, ma'am. Who's available to speak with her at this time?
I can speak with Your Honor.
I can.
All right.
Hassan, do you need to stay tight for your other case?
Yeah, I have another case, so maybe it would be
Judge, I could take it.
Thank you, Steve.
All right, so I'm going to send you to talk with Mr. Lockhart. You're going to get a notification from me now to go to breakout room number 1, ma'am. As soon as you receive that, as soon as you receive that, click right in, ma'am.
And may I have Miss Jamie Smith or Miss Andrea Gibson, please?
I'll make sure that happens.
Thanks, Judge.
All right, do I have on this Zoom, Martise Dumont living on Washburn on this Zoom? If you're on the Zoom, please say something. Washburn, address 16212, Martise Dumont. If you're on the Zoom, please say something at this time. Any occupant of 16212 Washburn, say something at this time. All right, it appears the defendant has not appeared. It is a first hearing. I will set it over for 5/18/21. If the defendant does not appear at 9 o'clock on that date, the court will entertain a motion for entry of default judgment. So ordered. Do I have Caprice Howard regarding property on Lappin Street? If you're on the Zoom, please say something. Caprice Howard on Lappin Street, please say something if you're on the Zoom. It appears the defendant has not appeared for this first hearing. I am setting it over for 5/18/21 at 9 o'clock a.m. Defendant does not appear at that time. The court will entertain a motion for entry of default judgment. So ordered. And Mr. Coleman, regarding the suffix 3469, I believe Ms. Rock is on the other side. You've been at your appearance previously in this regard, ma'am. So update me on what's going on here, ma'am.
Your Honor, Mr. Coleman has filed a complaint for health hazard in this particular case. We're going to be asking the court to dismiss that complaint as it is insufficient pursuant to MCL 600.5714D. It requires a serious and continuing health hazard, physical injury to the premises. I do not believe that Mr. Coleman has met that threshold, and as such, the complaint should be dismissed.
Your Honor, I would speak on that, Your Honor. The court, I have at least 11 affidavits which I can forward to the court. My clients are on the call right now. There's been no communication with the defendant in this particular matter. He's been threatening. He has failed to adhere to the lease agreement and his activity and behavior. He's used excessive noise, disturbing, harassing other residents. He has violated local and state mandates regarding his face, his mask, and one of the things in the common areas of the apartment complex. He has made it miserable for those who are living there. He's not even present today. And at this point in time, we believe that is paramount that we get him out of this property so that others can have an opportunity to have quiet enjoyment in their property.
Your Honor, excuse me, I'm sorry, Mr. Coleman. Your Honor, may I respond?
Are you done, Mr. Coleman?
I'm sorry.
Yes, you can go ahead and respond. I'll respond back, Your Honor.
Thank you. Your Honor, in the affidavits that Mr. Coleman submitted, they're all for one date, February 1st. They talk about the client going into a rant or a rage. There's no physical damage to the premises. It doesn't appear that he physically threatens anybody, and nothing is supported. Mr. Coleman has made these statements, but they're not supported by the affidavits. And the affidavits are dated April 12th, 2021. The incident occurred in February. Right now, it appears that Mr. Coleman's client is trying to jump the line ahead of everybody else. If they wanted him out, they should have filed a termination of tenancy. He does not meet the threshold. And I know Mr. Coleman has made these other statements, but right now they're hearsay and they're not supported by the affidavits that he has provided to me.
Well, Your Honor, what I will do, I have my clients on the call at this point in time. They can testify to themselves to the way they felt, how they were treated, and the continued activity by this particular defendant. My clients are concerned, as I stated, about others and their well-being. We have no problem. And in fact, I believe his lease agreement is up on June 30th. They will not be renewing his lease. They want to move forward without him, and their concern is for other residents who they have to look out for. And they can testify themselves to the day to what was said, how it was said, how they currently feel, and the fact that they still feel threatened by him and by his guests.
Excuse me, Ms. Rock, for 1 second, ma'am. How many units are in this particular complex? If you know, counsel, or how much?
I do not know. My client,
it is a multi-unit dwelling, correct, sir?
It is correct, John. It's Lafayette Tower. It's a very large multi-unit property, and in fact, I know there are at least two parts to Lafayette Towers. So it is not just a few people. We're talking about a great deal of people, and like I said, there has been no cooperation with defendant and with my clients.
All right, Ms. Rock, they want him to move out of there. I mean, does he have a plan to move or no?
Your Honor, unfortunately, I have not had contact with Mr. Randall recently, but I'm sure that since his lease is going to be running out, he's going to be forced to move. But again, Your Honor, the affidavits that Mr. Coleman submitted do not suggest a continuing problem. So it seems to me that they had every opportunity to provide affidavits that talked about other incidents beyond February 1st. I don't think he's met his threshold. The case should be dismissed.
Well, Your Honor, I can have my clients testify.
Well,
I guess the concern is that, to the extent that counsel wanted to amend this complaint to conform to a continuing type of situation, that he would probably be allowed to do that because of the rules as it relates to that issue. It looks like the type of situation where the court would likely conduct a hearing on this. And I know that there is some thought of a sense of urgency with regard to this matter. So let me get you the earliest date that I can give you to be able to take some testimony on this matter.
How long I'll do it?
As early as we can get it.
Earliest another Wednesday, you can go on 28th or what? 28th or 4/20.
Mhm.
At what time?
You can do like, you want to do 10 o'clock?
4:28 is the earliest I could give you. I was hoping sooner, but 4:28 at 10 o'clock.
Oh, I thought she said 2 o'clock, Your Honor. She said 10?
Said 10.
Mhm.
Yeah. 10
Okay,
o'clock.
sorry.
All right.
Thank you, Your Honor.
So I'll get right to it. I mean, I wish I could do it sooner than that. I know that it's a claim of some degree of urgency, but given the stuff I have already. All right. So that's the earliest we can get to it. I'll make a decision on that day. All right. So good day.
Thank you, Your Honor. Have a great day.
Thank you, Your Honor.
Regarding the suffix 1514, Mr. Salome is for the defendant in this matter. And Mr. Salome, if you will, sir, you previously ended your appearance. Update me regarding this matter, sir.
Yes, yes, Your Honor. So basically, I just wanted to inform Mr. Coleman as well as the court that we have filled out a SARA application for Mr. Grisham. He is present in court today. And there's just some, serious repair issues that would need to be made. And just wanted to mention that the apartment is not registered with the city. So those are some issues we'd bring up in the dismissal process with Mr. Coleman. So just wanted
Your
to,
Honor, first and foremost, the repairs, Mountain repairs have been made in a particular matter from my client. And as to the city of Detroit and it being properties registered, I think that has no bearing.
You're for some reason your sound is a little lower than it was previously. So.
Can you hear me now, Your Honor?
That's better, yes.
Okay. Your Honor, as far as the certificate of compliance, I don't see that as being an issue before the court at this point in time. We've not even got to a point where we've come to any resolution in this matter. My client will enter his application within SARA, and we can look at that point in time to try to resolve this.
yes, Your Honor, I just,
yes, Mr.
if I may, yes, as I was saying to Mr. Coleman, these are issues we can discuss between ourselves. I just wanted to get it on the record for the sake of just getting everything out there in front of the court.
Yeah, it's a good time to address whatever needs to be addressed. If it's already addressed, and that's a good thing. And I would indicate, as I've been requested to do so, but just because it is intuitive to do so, and that is that the issue of certificate of occupancy, certificate of compliance is becoming the issue. The city council, et cetera, are pushing that issue on ordinances that they had not enforced in any cogent kind of way over the last 20 plus, perhaps almost 30 years. Now, in this environment and beyond, that is becoming a critical issue. We're having some internal discussions as to what the court's approach has to be to those issues. It seems that the city has its duty to enforce its ordinances. It seems to some extent that there is an effort to transfer that duty over to the court in hearing matters in the landlord-tenant context. I have no problem with doing the part that it inures to me the execution of my duty as under the Summary Proceedings Act and other acts and statutes that are attached thereto. As it relates to an ordinance, a city ordinance, it is their duty to enforce that. And if a part of their enforcement is that the case cannot proceed if that is not in place, then enforce that. But the court can't make that decision sua sponte, that there is no statute nor is there any appellate decision that is directed the court to sua sponte make that kind of determination. I will say that under the statutes of the state of Michigan, that where there are conditions that substantially materially interfere with the reasonable habitability of the unit, then the court has the duty to make that inquiry and to make decisions as to how the case is to proceed accordingly. Moreover, the court has a duty that where there is a code violation or a ordinance violation, to take that into consideration in how it determines a case involving non-payment of rent. So all of those issues are coming to the fore. So I took a moment to express that to plaintiffs' counsels and then to everyone that the landscape is changing where the city is making the decision to act upon the ordinances that have been in place for some time. I think that's a good thing. It's happening now, though. It's not, it's not gradual. The estimation is that some 70 to 80% of the properties in Detroit are not properly registered, or do not have the proper certificate. So we're talking about 25% that may have it, 70 to 80% that do not have it. So it's a big change in the landscape. So I just wanted to let everybody know that because that's going to become a bigger and bigger issue as we go forward. All right, so I'm setting the date, setting this in CR protocol for 5/2021 at 9:00 a.m. And in the normal course of things, the court will address any issues that are pertinent to it, making any decisions regarding this matter. All right, regarding the suffix 1563 Open Door versus Stacy Sims, and do I have Ms. Sims on this Zoom? Stacy Sims, living at the property on Penrod. If you're on this Zoom, please say something at this time. Mr. Coleman, this was this one of the ones where there was a notice situation? I don't think so. I think there was a previous hearing on this one.
And I believe that one. I believe we should have dismissal on that one.
All right. That's 1563.
Let me just confirm the last three numbers are 1563.
That's correct, sir.
Let me confirm. I believe we sent a dismissal on that, Your Honor. If you can give me about 2 minutes, I will give Madam Clerk a call.
Yes, sir. I'll indicate that it is dismissed. If anything changes about that, sir, notify my clerk, and she'll make the adjustment.
Thank you, Judge.
Thank you, sir. Mr. Cox and Ms. Mulvey on the suffix 1249, Freedom Meadows versus Charles Pruitt. And you may, at this time, Ms. Mulvey.
Your Honor, if I may, Judge Aaron Cox appearing on behalf of the plaintiff, Your Honor. We did discuss in a breakout room, and I believe Ms. Mulvey was trying to get a hold of her client. And I think that's probably why she's not responding to the court's call at this time.
All right. So Mr. Cox, just one of you give me a signal and I'll come right back to you, Matt. I have it in front of me.
Thank you, Your Honor.
The court now calls 21-340-237. This is Victoria Place versus Angela Washington and other occupants of property located at 22327 West 8 Mile Road, B number 3. The court calls the suffix 0206 East State Fair versus James Iwankowski regarding property on March 19750 March, apartment number 1. Your appearance at this time for the FEMA firm, counsel.
Good morning, Your Honor. William Colbert, P49466, appearing on behalf of the plaintiffs.
All right, thank you, Mr. Colbert. Any counsel indicating for either of these defendants? All right, do I have on this Zoom Angela Washington, please? Ms. Washington? If you're there, say something at this time, Ms. Washington. Again, I'm looking for Angela Washington, living at property at 22327 West 8 Mile Road, B3. This is a complaint for a non-payment of rent. It is a subsequent hearing. It appearing now that defendant has not appeared, nor has defendant responded to the complaint.
Hello, sir. I'm sorry to interrupt you, Your Honor.
I haven't come to you yet, sir.
Thank you, Your Honor.
Under default as it relates to Ms. Washington on West 8 Mile Road.
Thank you, Your Honor.
And the court will find that the plaintiff has a right to possession, that the defendant must pay the amount set forth in the complaint subject to updates on or before the 23rd of April or after that date a writ will issue allowing for eviction from the property. The court now addresses the suffix 0206, and I see that Mr. James Iwanowski is on this Zoom. And Mr. Iwanowski, this is a complaint for non-payment of rent. This is a subsequent hearing. Have you put in an application for Sarah? What's going on in this matter, sir?
I tried to with Sarah, but it didn't work the way it would have.
Let me
I
stop you
recently,
let me stop you for one moment. Mr. Salome, did you talk with the gentleman?
No, I don't remember that I did, Your Honor.
Oh, okay. I'm sorry. I thought you were indicating. All right. Ms. Gibson?
Mr. Lockhart actually gave legal advice with him, for him.
That was at the previous hearing, Miss Gibson?
Yes.
Yeah, I recognize him.
yes,
All right,
sir.
very- Yeah. So you said that the SIRA application did not work, sir. So what's happening here? How are you resolving this matter, sir?
I recently got COVID, and the two places that I work at, Chipotle and Tropical Smoothie, Chipotle got cut down and they had to stop. And so the money I've been making is kind of been slim. I got a new car recently, so I had to finance that because I'm trying to go and finish school at MIAT, and I had to make sure I can get up there.
Judge, may I interject?
Yeah, let me see, Mr. Lockhart, tell me what you think is going on here.
Judge, when he says Sarah didn't work, I suspect he means that the program did not let him proceed. I have been told by several people that the brand new, the online application program that kicked off last Friday, April 9, has had some glitches in it. Sir, do you mean that it just wouldn't let you input your information?
Your Honor, he is correct. That is exactly what happened.
You need to try it again. They're working out the glitches. Judge, from all he's told me, and Mr. Lefevre, from all I hear, he's going to be income eligible for Sarah.
Yeah, that's what I was certainly thinking that it would be. All right, so let's see if we can get around the glitch.
Your Honor.
Go ahead, Mr. Aronowski.
Thank you. I was thinking about May 25th. This month I get paid twice before the 1st, so I can cover the rent for this month, which is $600. And by the time May 25th rolls around and I have to get approved to go back to work because COVID and all that, I should have at least most of it covered. If not, I really would like to keep my house, and I'm working 2 jobs.
Your Honor, can I go in the, oh.
Yeah, could I interject, please? Your Honor, Attorney Salome.
Everybody want to help you because you seem like the perfect candidate for a heart. Get us about the heart. You seem like the perfect candidate for SIRA funds, quite frankly. So I've got 2 lawyers raising their hand. I got an assistant raising their hand because you seem like the person that should be able to get some funds, and you're talking a different way now. So before we need a lobotomy, I'm going to go ahead and set you up with an attorney. So,
yes, sir.
So you can get your head on straight about this. I'm going to set your next date for the 20th of May at 9 o'clock a.m. That's a control date, May 20th, 9 o'clock a.m. And I'm going to send you in with Mr. Salome and Ms. Gibson. They'll speak with you. Let's see if we can get this lined up, and maybe you can get some help to kind of get this closed out. All right. And you have that date, Mr. Coleman, as well, sir?
I do, Your Honor. Thank you.
All right, so Mr. Lowakowski, I'm putting you in a breakout room right now, number 4.
Thank you, Your Honor.
And I have 2 more matters with you, Your Honor.
All right, I'll be right with you, sir.
Thank you.
Your Honor, could you just recite the case number for me, please?
That's 21-340-206.
Thank you so much.
Gibson, why can't I find you under a different device or something?
Judge, she may have already gone into the breakout room, to the prior one you sent her to, I suspect.
I don't see her in any breakout room. I don't see. Ms. Gibson, where are you?
Judge, I'm wondering if her internet went down. That happened Monday.
where is Mr. Okay, let me see. Okay, that took a little longer than it should have. All right.
Judge, would you allow me to interrupt or I'll?
Yes, sir. Well, let me find out, Mr. Coleman. I see one other matter.
There's one at 9
this is-
o'clock. It was 0233, and then at 10 o'clock, 4209. Both are East State Fair.
Were any of those dismissed, sir? Because the only one I have East State Fair versus Markeisha Williams under the suffix 4209.
That's the first hearing, right?
Yeah. So do I have on this Zoom Miss Williams, Markeisha Williams? Ms. Williams, if you're on this Zoom, please say something at this time. This is a first hearing regarding the property on East State Fair and regarding a complaint for non-payment of rent. I will set the matter over under the administrative order where the defendant has not appeared, setting that matter for 5/18/21 at 9 o'clock a.m.
Okay,
5/18/21 at 9 o'clock a.m.
Thank you, Your Honor.
Breakout. Or is Jamie on the job too?
The other one was 2134-0233.
Thank you.
It's a second hearing.
Good enough.
It's like at 9:30. Yeah.
All right, let me know when you can. Thank you. This is too much fun.
You got that.
He said it was 21 what?
Yeah, I'll give you that number again, Mr. Blair.
2134-0233. The address is 19751 Marks, Apartment 6.
Judge, it's your third case on the 9:30 docket.
All right, anyway, this is case number 21340-233. This is East State Fair LLC versus occupants of property at Mark Street. It's 19751 Marks, apartment number 6. The matter is before the court on a complaint for a non-payment of rent. This is a subsequent hearing in that regard. Do I have on this Zoom any occupant of the property on Mark Street, apartment number 6? If you're on this Zoom, say something at this time. Any occupant of 19751 Marks, apartment number 6? If you're on the Zoom, please say something at this time. All right, it appearing that defendant has failed to appear, it is a subsequent hearing. The court will now enter judgment by default on the terms created in the complaint, subject to updates in the amount. Said amounts would have to be paid by the 23rd of April or after that date, a writ will issue allowing for eviction from the
Judge, I'm sorry.
I'm sorry? Madam Reporter?
I couldn't hear you. Default judgment, and then what? 420?
Default judgment is entered in this matter. The amount set forth in the complaint would have to be paid by the 23rd of April 2021, or after that date, a writ will issue allowing for eviction from the property.
Okay, thank you.
Thank you, Your Honor.
Thank you, sir. Madam,
Wonderful day.
Put the coffee down.
Waters, thank you.
All right. Mr. Cox or Miss Madam Council, Ms. Mulvig, are you back on that? All right, this is case number 21340-295. This is Milton and Sequoia Ferguson versus Shannon Jones and Thomas Jackson and other occupants of property at 16130 Ashton Street. The court also calls at this time the suffix 0299. That is Mark Downer versus Angela Scott and other occupants of property on Burke Road, 12914 Burke Road. The court calls the suffix 3056. That's Kenneth Soboleski versus Yvette Goodman and other occupants of property located in the city of Detroit at 20543 Maraw Street. The court calls the suffix 0786. That is Julie Hendricks versus Kelsey Snail and other occupants of property at 9983 Warwick in the city of Detroit. First, as relates to 0295, your appearance, let me see, do I have Milton and Sequoia Ferguson on the Zoom? Say something if you're here. And Mr. Salome, are you there, or did I send him away? All right. I do see that there is a petition to withdraw. As counsel, the court did sign that petition. He has withdrawn. Do I have Shannon Jones and Thomas Jackson on the Zoom? Any occupants of the property on Ashton Street? Any persons regarding this particular property on this Zoom? Say something at this time. All right, that matter will be dismissed where neither party appeared. So ordered. The court addresses now the suffix 0299, I should say, Mark Downer versus Angela Scott and other occupants of property at 12914 Burke Road. Do I have Mark Downer on this Zoom? Say something if you're here. Mr. Downer?
Yes, Your Honor, Mark Downer.
All right, thank you, Mr. Downer. You own the property on Burke Road, is that correct, sir?
Yes, Your Honor.
All right, I have Angela Scott here. Ms. Scott, good morning to you, ma'am.
Good morning, Your Honor.
All right, and you live at the property here on Burke Road, is that correct, ma'am?
Yes.
All right, so what's going on in your case? Did you apply for SURE funds to get this resolved?
I did apply. I have not yet received anything via email regarding the application, but I did submit the application March 31st.
Okay, all right. And Mr. Downer, have you submitted any part, the landlord's part of that application, sir?
Yes, I did. I submitted it through the website that is out there through the, I don't know who's sponsoring it, but I'm told that some agency are having problem getting paperwork from that website, but I did submit it. And if I haven't heard anything back from this case on any side.
All right, so it sounds like the applications are in process, so I'm going to go ahead and set it for the next date, which is 5/20/21, and that's going to be
Your Honor.
stop for a moment. That's going to be at 9:15 a.m. And what I'm going to do is, somebody's talking, I'm going to have you to speak with someone, Ms. Scott, and maybe able to assist you in this regard. Who was speaking? Who's saying something?
That was me, Your Honor. Ms. Scott, I'm sorry.
All right. All right, so Ms. Scott, I'm going to send you to a breakout room to speak with someone just to go over what you've done to make sure that you got your end of the application in and everything's taken care of, so that we can make sure everything's lined up for the next day. Scott?
Okay, thank you.
All right.
And what was that next court?
The next court date, sir, that's going to be the 20th of May, and it's going to be at 9:15 a.m., sir.
Thank you.
Your Honor, were you saying that you needed somebody to speak to Ms. Scott just to make sure everything is filled out properly?
Yes.
Okay.
Yes.
I'm available if you need me.
What breakout room were you in, sir?
I was in breakout room 4, so I think there's a copy in there.
Oh, okay. Let me move some people around. Ms. Scott, I'm going to move you to, she's gone. And I'm moving you out of 4 to 5. All right, Mr. Salome, you're all set, sir. She's there.
Thank you so much.
All right, the court is addressing now the suffix 3056. It looks like Sobolinski. If I'm getting that wrong, please correct me. And then Yvette Goodman. Do I have Mr. Kenneth Sobolinski? Say your name, sir?
Yes, Your Honor.
All right, what's your name, sir?
Kenneth Soboleski.
All right, thank you, Mr. Soboleski. And good morning to you, sir. You own the property on Maross, is that correct, sir?
I do.
All right, thank you, sir. Let me see if I have Miss Goodman. Miss Goodman, are you on this Zoom? Yvette Goodman? The occupant of property on Moross Street, 20543 Moross. If you're on the Zoom, please say something at this time. It appears now that the defendant has failed to appear and has not otherwise responded to the complaint. The court therefore will enter the judgment now by default in order that the defendant move from the property on or before the 23rd of April, or after that date, a writ will issue allowing for eviction from the property. So, sir, you need to send in a judgment form with that that information on it, and you have the information where you send it, sir.
Are you talking to me, Your Honor?
Yes, I am. All right. So you got it. I granted you a judgment. Do you have the judgment form that you can send in, sir?
I do have one, yes.
You have the email address, sir?
I have an email address, yes.
All right, very well. So send that in and I'll sign it and you'll have your order. And that order will say the defendant has to move by the 23rd of April, or a writ will issue after that date, sir.
Okay, will do. Thank you very much.
Thank you, sir. Good day to you. The court now is.
I'm sorry, Your Honor. I didn't mean to interrupt.
Mr. Vajami, you have one case in front of me. I called it earlier, and it seems to me that it was a first hearing, and I set it up for a subsequent hearing. The defendant did not appear, so I gave it the date of the 18th. Let me just.
9.
I'm sorry.
18th at 9.
The 18th at 9 o'clock, 5/18 at 9 o'clock.
Thank you very much, Judge. Sorry, I was.
I meant to come to you when I first saw you in. I got busy with other stuff because I dealt with the one case where the defendant was not here. All right, sir. Good
Thank you,
day,
Judge.
Your
All
Honor,
right,
Diane Wyrock, have you called my cases yet?
Miss Wyrock, no, the one in front of me, and then you're next, ma'am.
Okay, thank you.
There you go. I got you in front of me somewhere. If you can see, that's you. All right. I'm dealing with Julie Kendrick and Kelsey Snell now regarding property on Warwick Street. If you on the Zoom, Miss Kendrick, say something at this time, ma'am. Julie Kendrick. Kelsey Snell, if Ms. Snell is on the Zoom, please say something at this time. Regarding property at 9983, any person regarding the property at 9983 Warwick. If you're on the Zoom, please say something at this time. It appears that neither party has appeared on this matter, nor have they responded to the court's call. The case accordingly at this time will be dismissed. The court calls case number 21-344-217. That is Midpoint Real Estate versus India Johnson and other occupants of property at 1260 Longview. The matter is before the court on the filing of a complaint for non-payment of rent. It is a first hearing. The court is also calling the suffix 4221. That is Midpoint versus Aisha Brown regarding property at 11369 Nottingham. That is a first hearing regarding a complaint for
Good morning,
non-payment.
Your Honor.
Your appearance at this time.
Good morning, Your Honor. Diane Wyrock on behalf of plaintiff P59773.
All right, thank you, counsel. And I'm looking now for Miss India Johnson. If you're here, say something at this time, ma'am.
I'm here.
All right, and good morning to you, ma'am.
Good morning.
You live at the property on Longview, is that correct, ma'am?
Yes.
All right. This is a first complaint for non-payment of rent. Have you had an opportunity to speak with an attorney regarding this matter, ma'am?
No.
All right. And have you put in any application applying for any funds or anything in regard to this case at this time?
No, I just heard about the CR program yesterday, and I was going to go ahead and apply for that today.
So what I'm going to do is I'm going to set it up so that you can talk to someone, a lawyer today in a breakout room, and you can go over what your rights are and also opportunities to resolve the case. And one of the ways that you may be able to resolve it is through the CR program. I'm going to go ahead now and give you a date that you are to return to the Zoom, and that's going to be 5/20, May the 20th at 9:15 a.m. May 20th at 9:15 a.m. That's when you're coming back in the Zoom, dialing the same information that brought you in today, ma'am. So,
okay, thank you.
All right, Ms. Johnson, so hold tight. I'm going to put you in to talk with someone that can go over what your options are. So I'm going to go ahead now and send you to breakout room number 1. And there's your notification, ma'am. And Mr. Lockhart, you have that spot. I'm looking for Ms.
Yes,
Gibson.
I'll take it, Judge, but could I suggest that if Ms. Wyrock's next defendant, Aisha Brown, is here, I'll take them both at the same time?
All right, so hold tight, Mr. Lockhart. I'm going to send Ms. Gibson to 1.
I'm going to, Ms. Gibson's internet has gone out at the Housing Coalition, so she may not be available. Oh, okay.
She's back, so she's there now.
I'll go to 1, and if Miss Brown shows up, if you'd send her as well, please.
Yeah, just hold tight for a minute, Mr. Lockhart. Ms. Gibson, you can go ahead in with Ms. Johnson. And Mr. Lockhart, if you hold tight, I believe that Ms. Brown is here. I'm looking for Aisha Brown now. Say something, ma'am.
I'm here.
All right, and good morning to you, ma'am.
Good morning.
All right, this is the first hearing regarding the complaint for non-payment of rent. Have you spoken with an attorney at all regarding this matter, ma'am?
No.
All right. So I'm going to get you in to speak with Mr. Lockhart, Attorney Lockhart, and I'm going to send you to the breakout room so that you can discuss this matter. I'm going to give you a new date. That date is the 20th of May, and that's going to be at 9:15 a.m. May 20th at 9:15 a.m. That's when you're coming back to see me. That's when you come back into the Zoom.
Okay.
May
I say something?
Yes, ma'am.
I did fill out for some type of public assistance that was back in December. I just haven't heard anything. I did get in contact with the landlord, and we do communicate about the things. I have let them know that I have filled it out. I just haven't heard anything.
Yeah, that was the old program, and they ran out of funding. So the new program is called the CR program. And the things that you mentioned to me, you'll want to discuss those with the attorney as you go in, and they'll be able to give you some guidance. All right. So here's your notification, ma'am, for the breakout room that comes to your device, and just click in there.
Thank you, Your Honor.
Thank you. Thank you, Ms. Wyrock.
Take care, Diane.
Thank
Judge,
you.
if you could, Miss Babcock is a new lawyer with our office who's here for her first time today. Could you bring her into breakout 1 with everybody too, please?
I will do so. I'm switching her from 2 to 1 now. There you are, Ms. Babcock.
Thank you, Your Honor.
Absolutely. All right, the court is calling case number 21-344-225. This is Juana Garcia versus Latoya King and other occupants of property located at 17546 Pembroke in the city of Detroit. And counsel, your appearance at this time, sir.
Good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of Juana Garcia.
Thank you, counsel. And the property at Penmore, let me see if I have Latoya King, Richard Passmont. If you on the Zoom, say something at this time.
We're present, Your Honor.
All right, what is your name, ma'am?
Latoya.
All right, thank you. And what is your name, sir?
Richard Passmore.
All right, thank you, Mr. Passmore. Good morning to our two of you. This is a first hearing regarding a complaint for non-payment of rent. And I want to ask you, Ms. King, have you spoken with a lawyer at all regarding this matter, ma'am?
No, I haven't.
All right, Mr. Passmore, you spoke with anybody regarding this matter, sir?
No, Your Honor.
All right. All right, so given that it is a first hearing under the laws of the state of Michigan, I will set it for a second hearing. That date is going to be May the 20th of 2021 at 9:15 a.m., 9:15 on the 20th of May. That's the next time that you'll come to court. I'm going to connect you to a lawyer that you can talk to and go over your case and discuss what your rights may be, and also discuss ways that you may be able to resolve this case, perhaps through the CR program or other resources that may be available. Mr. Passmore, you may, sir.
We are already connected with the CR program. We're just waiting on the funding.
All right, sounds good. And that's what several people are doing likewise. What I'm going to do is have you talk with a lawyer to make sure you got everything lined up, make sure that everything is all set so that you're covered with everything so that we get to May 20th. If they funded it, then you'll be one of the ones that's got funded. And if it's not, we'll know when it's coming, so on and so forth. So just hold tight for a moment. I'll get you to a breakout room and then note your date, May 20th, 9:15 a.m.
Okay.
Got it.
That's the date that you'll zoom back in. All right, Mr. Counsel, you got that date as well, sir?
I do, Your Honor. Thank you.
All right, thank you, sir. And so hold tight for just a moment, Mr. King, Ms. King and Mr. Passmore. I'm waiting for one of the lawyers to become available, and then I'll see you to a breakout.
Okay, thank you, Your Honor.
Thank you.
Thank you. Mr. Cox, are we still waiting? Ms. Mulvey, still talking? All right. All right, the court now calls case number 21-344-229. This is Traymore Apartments versus Ebony Diggs and other occupants of property located at 457 Brainard, number 207. The matter is before the court for a first hearing regarding a complaint for non-payment of rent. The court is also calling the suffix 4233. That is the Mount Vernon Apartments versus Keitha Bailey and other occupants of property at 677 West Alexandria, unit number 217. Both matters are before the court for first hearings. Your appearance at this time, counsel.
Yes, sir. Steve Gann, P78209, appearing for the plaintiff on both these cases. The Mount Vernon case that you called, that case has been dismissed. If the court doesn't have a copy of the dismissal, I can send another one over there. The only case we have still pending is Traymore versus Diggs, which is suffix ending in 4229.
Thank you, sir. The suffix 4233, that will be dismissed at this time. Regarding the suffix 4229, do I have Ebony Diggs on the Zoom? Ms. Diggs, Ebony Diggs, any person occupying the property on Brainard Street, 457 Brainard, number 207. If you are on this Zoom, please say something at this time. All right. It does appear that the defendant at this first hearing has not appeared and has not otherwise responded to the court's call. Accordingly, I will send it over as it is a first hearing for the 18th of May, 2021. That's going to be at 9:00 a.m. Ms. Smith, are you indicating on this case you have some information?
I was going to ask if I could join breakout room 5, Your Honor.
So you just interrupted me. All right.
So
all
sorry
right,
about that.
We'll get you there in just a moment. So 9:00 a.m., Mr. Gann. Good to see you, sir. Good day to you.
Thank you. Stay safe.
Likewise. All right, Jamie, let's get you. You said you're trying to go to
Breakout room 5.
Gotcha. All right, and we're waiting on Ms. Mobeck, counsel, whenever you're ready on that, we'll be ready to go. And Mr. There we go. All right, so we're back on the record in 1249 Friendship Meadows versus Charles Pruitt. And both counsel have ended their appearance, Mr. Cox, as well as Ms. Mobeck. Ms. Mobeck, let me know where things are at this point now.
Sorry, Your Honor. Yes, Angela Malvik, P83921 on behalf of defendant Mr. Pruitt. We were unable to work out an agreement and we are requesting a hearing on the complaint.
All right. All right. So what are the, I know it's a termination action. What are the significant issues?
Yes, Your Honor, it was filed under MCL 600.5714E that there were threats of physical violence or physical violence inflicted. That is the termination, that's the underlying reason for the termination action.
All right. So there is an ongoing lease, is that correct? Seems that way.
I believe the lease expired in March.
All right, very well. So I'll set it for you. What's the hang up here? Is there something about time or it's a matter of
Yes,
about time?
Your Honor, my client is trying to and is working into getting into assisted living. We are just waiting for final approval from a third-party insurance company to give the final approval. I spoke with the caseworker this morning. Once that approval is issued, he would be able to move into his new housing tomorrow. So it's just a matter of getting all the processes and steps completed timely. And as I'm sure you're aware with COVID, everything's moving a little slowly.
Yeah. Thank you, Counsel. Mr. Cox? Anything, sir? All right, so I'll set it up for a hearing in during the same day.
I was trying to find out if you can try. Yeah, I'll probably not, definitely not the end of the month. Unless you want to do the 14th. 14th?
May?
No.
Today?
Oh, today is the 14th. Duh. Oh, no, you don't have anything unless you want to go to the 28th. And then in May, you have the 12th. That's your next day.
Oh, yeah. Well, I'm going to stick it in on the 28th then. So 4/28, 10:30. All right, I'll address it at that time.
Thank you, Judge.
All right, at 10:30. All right. Good day to the two of you. All right. That is all of the cases that I have in front of me. I believe I finished the call, and Mr. Salami, are you available to talk with Mr. King and Ms. Passmore on 21-344-225? That's regarding Garcia versus Latoya King and Richard Passman. It's a non-payment matter. And it's a first hearing. So I've set it for 5/20 at 9:15. So I'm going to send the two of them, Mr. Passmore and Ms. King, into breakout room number 6, number 4. We're doing number 2.
Okay.
Mr. Salami.
Your Honor, you said that case number was 213-44225. Is that correct?
That's correct.
Okay. Okay. Thank you, Your Honor.
Thank you, sir.
Judge, I don't think Mr. Cox heard you.
I'll come to Mr. Cox in just.
Yeah, I'm sorry. Could you also send if Ms. Scott is in the room she's here. I think I'll just wait for Jamie maybe because I don't see anyone else here.
Right. I'll send either Jamie or Andrea as soon as they become available. They're both in the breakout rooms.
Okay. Okay. Perfect. No problem. Thank you.
Yes, sir. Mr. Cox.
Yes, Judge.
So did you hear me on the case with Ms. Mobic? That case is set over for the 28th at 10:30 for a hearing.
Set over to April 28th, Your Honor?
Yes. Yes, I was talking through the case and she was saying things. I thought you were there. and
I don't think you heard anything.
If it wasn't for the court report, the court reporter said, Judge, I don't think Mr. Cox heard a word you said.
And I didn't, Your Honor, and I apologize. I'm trying to juggle between Judge Milhouse and another courtroom as well.
Oh.
Okay, no problem, sir. So I sent it over. She asked that the court would set up a hearing on it. She also indicated, Ms. Mobic, before she left, that the defendant is in the process of getting moved out, and that move could be imminent. if he gets approval for assisted living. But be that as it may, the 28th at 10:30, I'll hear this and whatever testimony there is to get this resolved.
Thank you very much, Your Honor.
Thank you, sir. Good day to you.
You as well.
All right, Miss Halliburton, I think you raised your hand, ma'am. I cannot hear you because your audio is not connected.
Her case is dismissed, Your Honor. We told her that this morning.
All right, but your case is dismissed, Miss Halliburton. So your case has been dismissed. All right, good day. Good day to you, ma'am. All right, and okay. Anyone else here that believe that you have a matter that this court should address?
Still here. I thought y'all told her case was dismissed.
We told her that this morning, Deborah.
Yeah, that's what I thought I heard.
Even the attorney told her, and she still waited. She still wanted to. She was just giving us a hard time. I don't know. Yeah, she didn't believe it, but she needs to hear from the judge.
From the judge, yeah.
Yeah.
Funny how people are like that. Yep.
Told her and everything.
Okay, is this case dismissed 21-340-295?
Shannon Jones. Yes. That's the you said neither party appeared for Milton Ferguson. That was a pro per case.
Over.
Yeah.
Who is Lisa?
I don't know. If there's anyone that has business in front of me, please say something at this time. If you believe that you have a case or something you have not been heard on, please say something at this time.